Item number 1 to 11, pronouncement of judgment.
There is no reason why the respondent should not be regularized. We are minded to grant even further relief to the respondent than given by the learned single judge by directing that the interview specified in clause 4 would only be confined to factual verification of the identity, date of birth, and for checking up the service records of the respondent without in any way attempting to disqualify her on the basis of any material in the service records, and thereafter to regularize her in accordance with the administrative order of the government dated 23rd June 2022. This order is also passed in each of the appeals as it is incorporated therein. These appeals are accordingly dismissed. The impugned judgment and order of the learned single judge dated 28 May 2024 is affirmed, subject to the above modification. Compliance with this order is to be effected within 6 weeks of communication of this order.
Number 12. May it please the Lordship. Lordship, I brief this matter may be taken up at the end of the board, Your Lordship.
At the end of the
Board, Your Lordship.
why?
Lordship, as the leading counsel is on legs, Lordship.
You start. We cannot come back again. You start. If he is needed and he cannot come, we will see.
May it please the Lordship. Lordship, this appeal has been filed against the impugned judgment and order dated 18/2/2025. Impugned judgment and order is at page 58, Annexure 3. The operative part is at page 59, Lordship. I may be allowed to read, Lordship.
Yes.
Though Dr. Mojika learned DSGI for the respondent has produced a communication dated 19/9/2024, whereby the grievances of the petitioner is stated to have been redressed. However, it is submitted that the petitioner was asked to calculate and provide the arrear bills. Mr. B. Dev, learned counsel for the petitioner, submits that the petitioner is not aware of the parameters or how to calculate the arrear bills. He thus prays that direction be issued to the pay and account section of the respondents for calculating the same. Dr. N. Mujika, learned DSGI, submits that the petitioner is at liberty to approach the pay and accounts section who will cooperate and generate the arrear bills in question. Accordingly, on this submission, the petition stands closed and disposed of. Lordship, before I come to the infirmities with the impugned judgment and order, Lordship, I may be allowed to...
No, how does this question arrear bills arise?
That is what, Lordship. Before I come to the impugned judgment and order, Lordship, I may be allowed to submit what is the facts of the case, which I have filed the writ petition, which have compelled me to file the writ petition, Lordship. Lordship,
No, first you tell us arrear bill regarding what?
Arrear of SCP, Lordship. Was not
Arrear of?
arrear of SCP. SCP arrear. ACP, Assured Career Progression.
But here what happened, my lord, the ACP, he was granted ACP from a certain date, my lord.
What is ACP?
Career progression.
It's a pay upgradation, my lord, on completion of 12 years of service and then again 12 years of service. Now, my lord, he came before this honorable court for backdating his ACP, my lord. So during the pendency of the matter, we have backdated, addressed his grievance, my lord. The only question remains that how much will be the area, my lord, on account of backdating of his upgradation, my lord. So I submitted a recon approach because there was no mandamus or direction is required from the court for that purpose only.
ECP, it's suppose the person is terminated in certain post. He doesn't get promotion on the high post or then he gets an ECP, assured career progression. That is to his pay will be increased in his post.
At ACP, what happened, my lord, there is a central government scheme, my lord. If any government servant, there is no prospect for a promotion, my lord, then on completion of 12 years of service, certain financial upgradation is given to him, my lord, just to address his promotional prospects, my lord. So he came before this honorable court for anti-rating his ACP, my lord. So that will entail some kind of accumulation of areas, my lord, because pay will be increased from a backdate, my lord. So only the question of calculation, how much will be the area, that was his grievance. I said he can approach the pay and account officer and he'll cooperate with him in calculating that.
Lordship, my submission is that before Lordship, I come to the infirmities with the impinged judgment, Lordship. I may be allowed to take your Lordship to the facts of the case, Lordship.
Yes.
Lordship, what happened, Lordship? I was appointed in Assam Rifle in the year 1989. Therefore, Lordship, I was remustered in the year 1994. So, as per the Fees Pay Commission, I was entitled for the first ACP, assured career progression, in the year 2006, which was denied to me. Thereafter, Lordship, I filed one writ petition before this honorable court, and the same was allowed. Lordship, kindly come to page 32. Page 32 of the first judgment and order, Lordship, which is allowed by this honorable court, Lordship. And the operative part is at page 44, Lordship.
You first show us the communication dated 19/9/24,
1992.
produced by Dr. Mozika
Yes, Lordship.
in the trial court.
That is 99. Yes, Lordship, that is page 55.
Is he entitled to a second upgradation?
No, Lordship, my case was only for first upgradation. First of all, I was entitled to get my first upgradation, that is, Lordship, in the year 2006, which was allowed by this honorable court, Lordship, by judgment and order dated 13/4/2023, that is page 32, Lordship.
Now it is only a calculation
Yes,
matter. How will you agree by the judgment?
Lordship, I am coming, Lordship. I may be allowed to submit the backdrops of the case, Lordship. I will satisfy, Lordship, how I am agreed, Lordship. So, Lordship, kindly come to the judgment and order dated 13/4/2023, page 32, and the operative part is at page 51, Lordship. 44, my apology. Paragraph number 33, Lordship. I may be allowed to read, Lordship. Page 33. So,
So
Lordship,
they have done it.
no, Lordship, what I am trying to submit, Lordship, thereafter, Lordship, I filed 2 representations before the respondent to comply with this judgment and order, but they have not complied. They have simply neglected my representation. Thereafter, Lordship, I filed the writ petition before this honorable court. Lordship, kindly come to my prayer of the writ petition which I have filed before this before the landed single judge, Lordship.
Put it out.
Page 28. Page 28, my prayer, Lordship. The writ petition which I have preferred before the landed single judge, Lordship. It's page 28, Lordship.
So they have complied and fixed the date as 2006. It is just a mathematical calculation now.
Lordship, my prayer before the landed single judge was twofold, Lordship. First of all, to comply with the previous judgment and order and to pay the interest for the area, Lordship. So it was never addressed, Lordship.
Pendently light interest, my lord. In writ petition, I do not understand, my lord. You kindly see the prayer, pendently light interest. My lord.
You are asking for implementation of that order.
No, Lordship, I have paid before the landed single judge that I may be allowed the interest from the not from the date of entitlement, Lordship, but from the date they have failed to comply with the judgment and order, Lordship. That was my prayer, Lordship. They have failed to comply with the judgment and order dated 13/4/2023, which they are supposed to comply within 4 months, Lordship, but they have failed. But they have came before this honorable court with one letter. They are saying that they have complied with the judgment. So after more than 1 year, when I filed the writ petition before the landed single judge, they came before this. They came with this letter, Lordship.
May I submit?
Where is the order of the single judge?
Single judge, Lordship, imputed, Lordship, Improving order is at page 58, Annexure 3, Lordship.
No, of the
Okay.
first.
That's Lordship, page 32. Page 32, Lordship.
Interest has not been granted in this order. This is the
Lordship, Lordship, I am not saying that the interest to be paid from the date of entitlement, that is 2006. But I am saying they are liable to pay me the interest since the date they have failed to comply with the judgment of this order, Lordship, with the judgment and order dated 13/4/2023, Lordship. Lordship, in this regard, I may place some decision, Lordship.
only 1.5 years within. Have you submitted your arrear bill?
Lordship, already I have submitted before the learned single judge. I do not have any mechanism, Lordship, to calculate the arrear. But that was not considered by the learned single judge, Lordship. I do not have, because Lordship, the respondents, they are calculating my salary statement. So they have all the mechanism to calculate the arrears, Lordship. I do not have any mechanism. That is the fact.
You are the beneficiary. You do not have the records.
Lordship, I do not have the parameters how to calculate, how to come to the actual arrear, Lordship. I do not know, Lordship. It is an admitted fact, Lordship.
But that aspect has already been touched upon by the learned single judge in para 3 of the order, my lord, where I'll just read one line, my lord. Dr. So-and-so learned DSA submits that the petitioner is at liberty to oppose the pay and accounts officer who will cooperate and generate the arrear bill in question. So it's a very simple for him, my lord, to go and oppose the pay and account officer and work together and find out what is the amount, my lord.
Lordship,
Against that, he is filing an appeal, my lord, against this car. Moreover, my lord, the second aspect, his claim of arrear is from 2006, my lord. And when he approaches the court, my lord, in 2016. The first writ petition was filed in 2016, my lord. So he can sleep over his right for 10 years, my lord. I'll just point out, my lord, at page 32 is the WPC of 2016. My lord.
We formally admit this appeal. On hearing submissions of learned counsel for the parties, we are in a position to dispose of this appeal today itself. On the papers in the memorandum of appeal.
may I please, Your Lordship?
In fact, this is really not an appeal, but an application seeking clarification or implementation of the impugned judgment and order dated 18th February 25. We dispose of this appeal by directing the respondents to calculate the, within quotation, arrear bills of the appellant within 2 weeks of communication of this order, and to make payment of the sum arrived at strictly in accordance with the communication of the Lieutenant Colonel O/C Legal Cell dated 19th September 2024 at page 55 of the Memorandum of Appeal, make payment to the appellant. Within a further period of 4 weeks from the date of generation of the, within quotation, arrear bills. Paragraph. Learned counsel for the appellant pays for interest on this sum. Paragraph. We are not in a position to grant the same for the reason that this matter was dealt substantively by the learned single judge in an earlier writ petition WP number 144 of 2016 and dealt with by the order and disposed of by the order dated 13th April 2023. Directing grant of benefit to the appellant under the ACP/MACP under ACP/MACP provisions. We are all aware that the entire reliefs that the appellant is entitled to has to be claimed in a proceeding. And the reliefs cannot be split into several proceedings. Full stop. In other words, under Order 2, Rule 2 of the Civil Procedure Code, the entire reliefs in respect, the entire claims in respect of a cause of action has to be made in one proceeding. Full stop. Here it appears that in this earlier proceeding, there was no claim for interest, nor had the court occasion to consider it. in our view, it cannot be claimed or considered now. Very well. But we make it clear that if there is further delay in payment of the above dues of the petitioner, of the appellant, he will be entitled to claim interest in accordance with law in an appropriate proceeding. This appeal is accordingly disposed of.
Number 15.
This appeal is accordingly disposed of. The impugned judgment and order is affirmed with the above observations and clarifications.
Number 15.
Yes. Yes, please.
May I please, Your Lordship, I pray that Your Lordship may kindly accommodate us 2 more weeks, Your Lordship, for this matter.
You are for the appellant.
No, Your Lordship, I'm from the respondent, Your Lordship.
You're praying for adjournment.
Yes, Your Lordship.
Yes, what do you say?
I have no objections, Your Lordship.
No, for the prayer of adjournment, what do you say?
No objection, Your Lordship.
When you want the matter?
After 2 weeks, Your Lordship.
Give the date.
On 16, Your Lordship, 16 April.
All right. By consent of learned counsel for the parties, this appeal is adjourned till 16th April.
Obliged, Your
Much obliged,
Lordship.
Your Lordship. Number 16.
Yes.
May it please Your Lordship. Lordship, this is an appeal against the impugned judgment, Your Lordship, passed by the learned single judge, Your Lordship. Lordship, the fact of the case is done. The respondent writ petitioner, Your Lordship.
You are ready to proceed with the appeal. Then we will pass over for a short time and come back and call the other matters and come back. You are ready to proceed.
Well, I am for the respondent. I am ready.
Lordship,
You are ready?
Lordship, if this matter can be taken up on third, Your Lordship.
That's the only thing, Your Lordship. I have already retired. No, because of this case, my lord, my pensionary benefits and other things could not be processed.
On third, Your Lordship.
What do you say?
On
Third.
third, Your Lordship.
On the prayer of learned counsel for the appellant, this appeal is adjourned till the 3rd with the observation that no further adjournment will be
No,
granted.
I'm not going to.
Lordship. Obligement.
Oblige, Your Lordship.
17.
On the 3rd, I'll be sitting at 2 o'clock. So this is the only matter in the list. Along with any short admission matters. Yes?
May I please, Lordship?
Yes.
Your Lordship, I'm praying for some accommodation for today in this matter, since the conducting counsel is having some personal difficulties for today, my Lord.
Item number?
17, Your Lordship.
Item number 17, Lordship.
What do you say?
So I have no objection.
When you want it?
A week time, Your Lordship.
Fourth April? 4th April.
Would Lordship will be taken up on 10th, maybe.
It is a holiday.
2 weeks or something.
10th is a holiday.
10th is a holiday.
11, 12, after 10th.
Well, what is the difficulty on the 4th?
No difficulty, Lordship.
Then, just for nothing, delaying matters. By consent of learned counsel for the parties, 4th April.
Value of Lordship.
Pleasure. Number 18. In this matter, my lord, I'm praying, my lord, if this matter can be taken up tomorrow, my lord. Today, my lord, the council have some personal difficulty.
Tomorrow I am not available. On some family program I am going out of state.
Then 4th April.
Hi.
Pleasure.
Saved by consent, 4th April.
All right, I'll leave this.
Yes, call the fixed matter, please.
Item number 13 and 14.
Other matters are over.
My Lord, I'm being led by Mr. Jishnu Saha, Senior Advocate, my Lords. My Lord,
We have given him leave to join virtually. Whenever he joins, he will join.
my Lords, if he's logged in, my Lords, if he may be permitted to be unmuted, my Lords. I think he's joined.
Yes, admit him.
My Lords, I think there seems to be some technical issues. My Lords,
Why don't you start?
My Lords, Mr. Saha was in personal difficulty today, my Lords. If one accommodation would be requested, my Lords, in fact, we had attempted to mention the matter yesterday, but my Lords,
I was told that he wanted to appear virtually, which that leave has been granted.
my Lords, we in fact were planning we wanted to mention the matter yesterday, my Lords, but the registrar didn't provide us with the link for today, my Lords. He said we could only be able to appear today. Mr. Sai is in fact in a little bit of a personal difficulty today, my Lords. Some accommodation may be granted today, my Lords. I am personally here from Delhi, my Lords, where Mr. Saha was leading us is in personal difficulty today, my Lords.
So since this matter is fixed, you at least proceed to some extent.
My Lords, I understand we were attempting to mention it for the last 2-3 times. We
Are you
attempted
in
to
a
mention
position to proceed, or otherwise we will have no option but to adjourn the matter? That's all.
My Lords may kindly adjourn it because Mr. Saha is in some difficulty, my Lords.
You
We would have saved the time to the court if we were
you don't engage any juniors.
Apology, what?
You don't engage any juniors in the matter who can at least proceed till he joins the link, or this matter is specially fixed today.
My Lords, we do that. In fact, my Lords, we attempted to mention it so that the court's time is not wasted today, my Lords.
We have been brought up in this culture that if a senior is ready, junior should be able to proceed with the matter.
My Lords, I understand, my Lords.
Not that I can't even submit one line.
No.
That is not.
No, absolutely. That I completely appreciate that, my Lords.
Not that you will be asked to conclude. But then since the matter has been fixed, some decorum has to be maintained that you proceed for some time and seek adjournment.
My Lords, I bow down what is falling from my Lords, my Lords. I completely appreciate that, my Lords. Just one instance today, my Lords, even despite our attempts to mention it, we couldn't mention it today. I apologize for the inconvenience caused, my Lords.
Mentioning was not mentioned because the registrar came to my chamber and said a virtual accommodation was sought.
My Lords, we attempted to mention it yesterday. My Lords, we attempted to mention it yesterday, but we were not provided with the link, my Lords. The registrar didn't provide the link to us, my Lords, yesterday.
I don't know.
I believe the respondents also have sought for a short accommodation, Lords.
And Mr. Saha has informed Mr. Banerjee that he is having some difficulty, my lord, on today. That was communicated by Mr. Saha to Mr. Banerjee, Mr. Lord. So therefore, we are in any case that matter has to be taken up, and then only it can be adjourned, my lord, or proceeded with.
All right, please write down. Much to our dissatisfaction, after the appeal has been specially fixed today, it is also fixed tomorrow.
Tomorrow and day after tomorrow.
Today and tomorrow, leaving aside
Up till 28th tomorrow.
all matters. A prayer for adjournment is made when the matter is called on. Paragraph. List these appeals. More than one appeal or one appeal?
Two writ petitions.
Two writ.
Two writ petitions.
List these writ petitions on 3rd April as to be mentioned to fix it further dates for hearing of the matter. Instead of appeal, make a writ petition. Let it appear as to be mentioned, you agree on a date and come.
Yes, ma'am.
3 consecutive dates.
Yes.
Humble apology, my lord. Much obliged.
You write that?